Good morning, everyone. A warm welcome to all of you here at National Law University and Judicial Academy, Assam. We are privileged to host this special event and are deeply honored by the gracious presence of our esteemed guest, Honorable Mr. Justice P. Naveen Rao sir, former judge of the High Court of Telangana. May I request Honorable Vice Chancellor sir, Professor K.V.S. Sharma, to kindly lead our esteemed guest to the dais. To begin with today's proceedings, may I call upon Honorable Vice Chancellor sir to please deliver the welcome address.
Honorable Sri Justice Naveen Rao, former judge, High Court of erstwhile state of Andhra Pradesh and Telangana. Later on, it was separated into independent state. It is Telangana, for the state of Telangana, separate High Court was there. And Lordship worked as acting Chief Justice before retirement for Telangana High Court. I welcome Lordship to this function. And in reference to NLUs, there are 27 NLUs as on today, Lordship. Out of these 27, first law school was established in the year 1986 in Bangalore, then in Bhopal 1987, then Nalsa 1998, then NUJ's Calcutta 1999. In 1999, two law schools were established, Calcutta and Jodhpur also. And NLU, National Law University and Judicial Academy was established in the year 2009. But actual academic program started in 2011. This is the 16th National Law School out of 27. And we got a 2-year lordship, 12B also, and NAC also this year they visited and they gave us B++ grade. So with this certificate we are entitled to start online courses, distance mode also. Now this year onwards we are planning to start MA IPR and BAL, Bachelor of Academic Class, through distance mode, 3-year. And we got income tax exemption certificate 50%, so that if any donor gives donation, 50% tax exemption they get. And we also got CSR. We registered with the Ministry of Corporate Affairs, so any company or industries can donate so that they can show it in 2% under 135 to 138 of Companies Act, 2% net profits. And in 2011, we started 5-year law course. As on today, first batch, they passed out in 2016. So almost 13 batches they passed out lordship till today. And LLM also almost more than 11 batches they passed out. And PhDs roughly more than 15. More than 15 PhDs the university awarded as on today. So with this, I request Madam to continue the proceedings. I welcome Lordship, I welcome students, faculty members, everyone to this particular occasion. Thank you very much.
Thank you, Honorable Vice Chancellor sir, for the welcome address. On behalf of the university fraternity, may I request our esteemed Vice Chancellor to present Lordship with a token of gratitude for being present with us today in order to animate NLUJA Academia and to support our journey. Thank you, sir, for doing the honors. We are truly honored to have amongst us today Honorable Mr. Justice P. Naveen Rao sir, whose illustrious career and profound contributions to the legal field inspires many. My proud privilege to present the Lordship's bio note for kind attention of the audience. Honorable Mr. Justice P. Naveen Rausa is a distinguished jurist who has made significant contributions to the Indian judiciary, particularly within the High Court of Telangana. His tenure is marked by a commitment to legal clarity, administrative reform, and the promotion of linguistic inclusivity in the justice system. Lordship has served as a judge of the High Court of Telangana, where he was renowned for his incisive legal reasoning and dedication to upholding the rule of law. Through his judicial career, Lordship has delivered several landmark judgments that have had a lasting impact on Indian jurisprudence, such as the adoption and co-personary rights, which provided the much needed clarity on the rights of adopted children under Hindu law. Lordship has addressed the complexities surrounding citizenship and statelessness, emphasizing the gravity of depriving an individual of citizenship and the need for careful consideration of such matters. Lordship's judgments also underscore the judiciary's role in ensuring fair administrative processes. Breaking new ground, Lordship delivered the first ever High Court judgment in Telugu, challenging the prevailing notion that legal judgments must be in English. This initiative not only honored the linguistic heritage of the region, but also made legal proceedings more accessible to the local populace. Beyond his courtroom duties, Lordship was a visionary in judicial reforms. He played a pivotal role in conceptualizing and establishing integrated family courts known as Kalpataru in Hyderabad. His efforts extended to the development of modern district court complexes and specialized courts for family and POCSO cases. Lordship championed the establishment of agri-legal aid clinics and introduced a defense counsel system under the legal aid model, setting a precedent for nationwide judicial support systems. Emphasizing the importance of technology in the judiciary, Lordship advocated for digitization and conducted numerous lok adalats facilitating swift and efficient justice delivery. Lordship's illustrious career reflects a profound dedication to justice, legal innovation, and social advancement. It's now my privilege to invite Honorable Mr. Justice P. Naveen Rausa to deliver the special lecture, please.
Sri KVS our Chancellor of the University, Sri Gunajit Raj Chaudhary, Registrar of the University, faculty, persons pursuing the LLM courses, and students pursuing the 5 years law courses. Good morning, all. I have something to say in the introduction about mediation. It's a known predetermined mindset not to jump conclusions, have guided conversation, and have a collaborative process. These are the essence of successful mediator. I want all of you to adopt these essential requirements, to be patient on a dry subject of this nature. I'll try to guide you. My endeavor to be present here and be part of this gathering is to just guide you of how the mediation and arbitration and mediation are developing and how are the prospects for law student to pursue. It's my pleasure to speak with young minds such as you today about a field that is increasingly reshaping the landscape of justice. We are calling this as alternative dispute resolution. But according to me, it would be more fitting if we call it as appropriate dispute resolution. A smarter, tailored approach to conflict that focuses on efficiency, cooperation, and mutual benefit. My experience as a lawyer and as a judge, and post-retirement as arbitrator and as mediator. And during the course of our discussion today, you will understand why I am calling it more as an appropriate dispute resolution. As you know, normally the disputes have to be resolved by the regular courts. But huge pendency in the courts. At least the rough estimation is about 6 crores of cases are pending all over the country. To dispose of these 6 crores of cases, you need enormous infrastructure facilities, trained people, and time frame for completion of the exercise. It is impossible, according to me, I can both say that it is impossible for ensuring the disposal of this number of cases. The inflow is more and outflow is less. So therefore, there is more accumulation of cases than the cases required to be disposed of. In addition to the cases which are pending in the courts, there are lakhs of cases pending in the statutory tribunals established over a period of time. These tribunals were established for two purposes. First is that they wanted technically competent person also to handle the matters such as income tax, excise, telecommunications, service matters, and for ensuring speedy disposal. If you look at the creation of administrative tribunals, the Act envisages that the matter of coming before the tribunal should be disposed of in 6 months. But even for 6 years, that disposal is not happening for various reasons. One, even though institutions are created in this manner with an idea of reducing the burden on the regular courts, and the regular courts spending time more on more serious matters, but infrastructure facilities are not provided to them, appointments are not made on time, and when you are choosing appointment to these statutory tribunals with specialization, if you don't choose persons with special knowledge, again it will create trouble. So therefore, even in the tribunals, the disposals are not happening. In addition to the statutory tribunals, there are statutory authorities created within the administration system who deal with disputes. There also again number of matters are pending. It's kind of where if the disposal does not happen at one particular stage, it results in unavoidable litigation also. So multiple litigation is happening because of the disposal process is not correct or not properly undertaken on basic principles, like you don't follow the principles of natural justice, giving opportunity of hearing the person and then assigning reasons for passing an order given by an executive authority. That leads to avoidable litigation. So, cumulatively, I would say at least 8 crores of cases are pending in various institutions which require a decision in favor of one or the other. Since this is the problem, what is the alternative to this is the one that everybody is envisaging. Like one in a stage, as I said, the tribunal system was invited, and then the tribunal system also failed. Thus came this concept of arbitration, mediation, negotiation. And more people are paying serious attention to this, not only in India, but all over the world. According to me, this predicament, the traditional adjudication mechanism, throws up challenges and opens up new opportunities to the young minds sitting here. Historically, mediation, conciliation, and arbitration are ancient theories which were in existence in our country. We, as part of Indus civilization, believed in wisdom, reason, and prudence to resolve disputes, originating philosophies of mediation. The modern legislative theory of arbitrage for deciding cases of members of commercial bodies and association of merchants have its roots in ancient country like India. One other practice in vogue, which was participatory method of dispute resolution, that is what is now called as modern mediation. I come from rural village. My father was the serpent at the Gram Panchayat for about 50 years. And as a young boy, I used to observe closely when the disputes was sought to be brought before my father. The village elders used to assemble. Both sides of the dispute party were called. They were asked to deposit a small amount of 10 rupees, 15 rupees, or 50 rupees. And then the elders would understand, will hear them, and then decide the dispute. Once the dispute is resolved, then and there itself, the persons who are fighting against each other, they come together and live happily. This system was prevailing for centuries in our society. Only the Britishers have changed the concept, and they've introduced their Anglo-Saxon legal system, which created more problems than resolving the problems as we are now facing. According to me, even if 10% of the entire litigation pending in the courts, institutions, tribunals, statutory authorities, it would be around 60 to 80 lakh cases. Even if these 60 to 80 lakh cases are diverted to the alternative means of resolution of disputes, it will be huge number of matters to be handled by lawyers, judges, or arbitrators, mediators, and that is, according to me, is a huge quantity of matters pending for consideration, would be coming up for consideration, if not more. I am only indicating this to tell you that the scope is enormous for all of you to think and take up the assignment as an arbitrator or a mediator as your option after you leave the law course. One of the most appealing aspects of both arbitration and mediation is confidentiality. Unlike court proceedings, which are typically a matter of public record, these alternative mechanisms offer privacy. This confidentiality can be crucial for business concern about protecting sensitive information or individuals seeking to keep personal matters out of the public eye. The cost effectiveness of these mechanisms is also a major draw. Accessibility is another significant advantage. These methods are adaptable to various situations and disputes. The ADR mechanism also boosts foreign investment and business confidence. I just pause here for a minute to tell you why the ADR mechanism would boost. One of the serious concerns expressed by the multinational companies proposing to invest in India was that whenever a matter or legal dispute arises and the matter goes before the court, it takes years for resolution of the dispute, and affecting their business prospects in carrying out their business. This was a real issue and a serious issue. But that was one of the motivating factors for introducing the Commercial Codes Act, bringing into effect Commercial Codes Act. Commercial Codes Act wanted to divert all the commercial disputes to special courts and a more easier manner of dealing with the technicalities of pleadings, etc. is introduced, time schedules are prescribed. But still, again in the commercial courts, the disposals are not happening, the cases are pending. Therefore, this is one reason why Commercial Courts Act happened, but the concern is serious and it's true. Therefore, the government has been attending to the concerns and how the Arbitration Act is amended time and again. There are further amendments are being brought about now. The Mediation Act is introduced, bringing about a change in the perspective of how to attend to a dispute that arises between the governmental organizations and private organizations within the private organizations. Arbitration serves as a structured process where parties present their cases before a neutral third party, the arbitrator, who acts similarly to a judge. The key distinction is arbitration isn't bound by formal courtroom procedures, giving room for customization. This flexibility often translates to faster resolutions compared to traditional court proceedings. Additionally, parties can choose their arbitrator, someone with expertise in the specific field of the dispute, ensuring a better understanding of the nuances involved. The award of arbitrator gives finality to the dispute, except few areas of challenge. But you may have noticed several judgments rendered under the Supreme Court and various high courts, indicating the scope of involvement of courts, interference by the courts, whenever an award is challenged under Section 34 of the Arbitration Act. The very narrow scope is given. The Arbitration Act also eliminates, as per the judgments rendered by the Supreme Court and the various courts, high courts, that any interlocutory order passed by the arbitrator in the process of pending arbitral proceedings cannot be challenged, but the person can avail the remedy of even a challenge to the arbitral proceeding, those proceedings, only after an award is passed. This manner of non-interference by the courts when the arbitral proceedings commence is helping in uninterrupted continuation of the proceedings. Another advantage of arbitral proceedings for early disposal is one is the timeline prescribed by the Act. Act prescribes a particular time limit for completing the pleadings. And after the pleadings are completed, prescribes another time limit for completion of the entire arbitral proceedings. There can be seeking of extension of time, but again is limited to a particular period, and then thereafter it's only the court which can grant extension. So there are constraints of not to stretch the arbitral proceedings beyond a particular time. Therefore, people are compelled to complete the proceedings as early as possible. The arbitrators also being away from their like me, I'm no more concerned with the judicial process, adjudication process. Therefore, I spend more time in dealing with arbitral matters. Therefore, I insist for hearings of the matters thoroughly and taking of the matter and then rendering the passing of an award. So the time constraint imposed by the Act and normal requirement of early disposal of arbitral proceedings is helping in early conclusion to a dispute. Since regular court procedure requires a lot of time consumption in settlement of disputes, most of the commercial contracts, even the family dispute settlement, the agreements arrived at among the family members and business community, or incorporating an arbitration as one of the means of settlement of dispute before any person seeking to take recourse for legal remedies. In fact, most of the contracts, I would say 99% of the contracts entered into by the parties on any commercial dispute automatically incorporate an arbitration clause as mandatory settlement process for resolving the dispute. Nowadays, even mediation is also being introduced. Therefore, arbitration is growing. Almost an arbitrator is required to deal with various kinds of disputes, as you know, matrimonial, commercial, and family courts. In commercial, there is again separate branches. Pharmaceutical sector has a lot of litigation. IT related litigation is also increasing day by day as IT companies are coming, more IT companies are coming into the business. As I said, family disputes are also being referred to the arbitration. Since most of the commercial disputes may involve technical aspects in addition to the implementation of normal terms of contract, understanding those clauses and then interpretation of those clauses. There can be more technical aspects of any particular field like pharma field. The person's knowledge about the pharmaceutical sector, would help him in analyzing the dispute in a more proper manner and rendering a proper award which can be acceptable to both parties. Therefore, it would be better to a person to acquire expertise into specialized fields. Of course, arbitrator can always take assistance of experts. But if he has an in-depth knowledge of all kinds of law and the particular technical subjects, it would be helpful to him to be a better arbitrator. Therefore, if you have a desire to be an arbitrator after your course is over, I would request you to acquiring these special skills now only and be ready to take the assignment as an arbitrator soon after you complete your course. There are not enough legally trained arbitrators to handle the workflow. Getting assignments as arbitrator is going to be bright. Acquiring special skills also helps in taking up assignments to represent as a lawyer to a party before the arbitrator. In fact, there has been a demand for having a separate arbitral bar at every stage, every state, every area. The potential, according to me, is huge. I would say that in Hyderabad, the arbitrators are busy handling several matters. The lawyers practicing before the courts are not able to appear before the arbitrator on weekdays because of their commitments in the courts. Such accommodation is happening now, but it may not be possible as arbitration landscape grows. And a separate bar of lawyers practicing in arbitration is needed there. To start with, law firms and senior lawyers are enrolling young lawyers to assist them exclusively in arbitration matters. This may even grow to make separate law firms that are coming up and dealing only in arbitral matters. Even the arbitrators are utilizing service of trained law graduates to help them in attending to arbitral proceedings, in legal research and drafting of awards, to act as a tribunal secretary. With increasing global trade and investment, international arbitration has emerged as a key method of dispute resolution. There are large opportunities for arbitrators, lawyers specializing in arbitration in industries such as construction, finance, intellectual property, sports, and energy. Singapore has emerged as a global hub of international arbitration and mediation. Now Dubai has taken over most of the work eager to handled by Singapore. I would say soon it may be India. In the the last few years, about 4 or 5 years, several arbitration and mediation centers are established at the cooperation of the government or concerned state. And these arbitration and mediation centers are providing all the infrastructure required for arbitrations to be conducted, mediations to be conducted. They also train, and if you closely look at the provisions of Arbitration Act and the Mediation Act, these institutions will be playing a larger role even in assigning matters to arbitrators and mediators. As an arbitrator, experience specialization and track record, built reputation. Well-known arbitrators can be called upon to serve in high-stakes international disputes. Membership in leading arbitration organizations such as ICDR, AAA, NCAA or ICC can also provide networking opportunities and further enhance career growth. Unlike arbitration, mediation does not involve a decision maker. Instead, it relies on a mediator, a neutral facilitator who assists the conflicting parties in reaching a voluntary and mutually acceptable agreement. Mediation assures autonomy of process and outcomes. The parties retain the right to terminate the mediation process at any time, and most importantly, to decide how the dispute will be settled. Mediation is an informal process. There are no strict or binding rules of procedure. Mediation is a completely confidential process. Mediation enables disputing parties to interact even on one-to-one basis. The legal recognition of mediation in India finds its roots in the Industrial Disputes Act. The Legal Services Authorities Act of 87 was enacted to encourage settlement of dispute by way of negotiations, arbitration and conciliation. As I was referring, Indian Parliament enacted the Mediation Act in 2023 with aim and objective to promote and facilitate mediation for resolution of disputes, to enforce mediation settlement agreements, provide for a body for registration of mediators, to encourage community mediation and to make online mediation. This act is going to be a game changer in resolution of disputes, and if implemented effectively, it will go a long way in reducing cases in courts of law. That is only I assume, I hope and I wish. However, Act does not make mediation as mandatory. The reason why Act is not making mediation as mandatory, and the reason why I am addressing you and requesting you, is to conduct mediation. If the Act makes the mediation as mandatory, as the Family Courts Act provides for and the Commercial Courts Act provides for, there has to be trained mediators who can handle the mediation with the contesting parties, advising them and then ensure of settlement if possible. There are not enough trained mediators available in the country. So the Act cannot impose a mandatory mediation unless infrastructure facilities are provided. Probably this was the one reason why the Mediation Act has not envisaged mandatory mediation. You may have seen, Family Courts Act requires resolution of family disputes by mediation. But the practical difficulty is there are not enough personnel who are well trained to deal with mediation matters to resolve the dispute between the family members. So actually it is not happening, and the courts come back to the cases come back to the regular family courts and then get pending for a long time. Commercial Courts Act also makes it mandatory for any person to, before invoking the mediation, availing the remedy before the civil court, he must explore the possibility of resolving the dispute by mediation. If mediation is not successful, then only he can go before the civil court or commercial court, filing a civil case. There is small exemption clause provided, and most of the time that clause is being exploited by the people who want to litigate directly without availing the remedy of mediation. That is, there is an urgency in any matter, and if the litigant requires an urgent order, he can bypass availing the remedy of mediation and go before the court directly and ask some interlocutory remedy. But courts have made it very clear now that this requirement of Commercial Court Act is mandatory and first has to be complied unless the litigant shows urgency to come to civil court without availing the remedy of mediation. I would say that this is the trend which will go on increasing in future, and mediation will be made mandatory in all proceedings, legal proceedings, before a person can seek to avail the legal remedy in the courts of law. To be a mediator or negotiator requires a mindset to look at how a dispute can be resolved. Needs thorough training on techniques of mediation, negotiation and conciliation. Practice on how to deal with various situations that throw up as parties sit across seeking to resolve their disputes. Community mediation centers also provide voluntary and paid up opportunities. It is not confined to domestic conflict. There are also areas for international peace, mediation and cross-cultural conflict resolution. At this stage, I wish to share few of the mediation matters handled by me as to how the mediation process sometimes is very satisfactory. Sometimes it's also frustrating because the parties come to one particular stage and then again move back. They move forward and then go back. Just wanted to share few examples of how the issues can be resolved or can be broken at the last minute. In one matter, it belongs to state of Andhra Pradesh. The lady lives in state of Orissa. She filed an application in Supreme Court asking for transfer of case from state of Andhra Pradesh to state of Orissa. The case filed by the husband for granting divorce. That stage, the matter was referred to mediation center. During the mediation, the wife has agreed for taking divorce. That is a plea raised by him in the case filed before the court in Telangana and Andhra Pradesh asking for divorce. And the lady has agreed after mediation sessions, she has agreed to take divorce. This would have been easily accepted by the husband and the problem would have been solved. But husband was not willing to accept the resolution of the dispute at that stage, only on the ground that when he went to Orissa to attend an investigation of a crime filed by the wife, he was ill-treated by the family members. Their close relation was ill-treated. They were beaten in public. They were taken to a police station and kept in the police station for a long time. And therefore, he said, I will fight the litigation and get an acquittal from the court honorably, but I don't want a kind of settlement. I told them, particularly that boy, that she is agreeing for resolution of the marriage. You will be free now. She is agreeing for closing of all the criminal cases filed by her. Then there is no problem for you. Why don't you agree? He says, no. I want an honorable acquittal in the court immediately, but not in this manner. I told him again that this will be causing a lot of inconvenience to you because that person is actually working in Hyderabad. You'll have to always travel to Orissa to attend to criminal cases. It will be very difficult for you. It will be time consuming. Then you'll have the stress and strain of going again and again attending to criminal cases. You never know what would be the result also. Now that she is agreeing to withdraw the cases, why don't you settle? The boy refuses to settle and ultimately it could not be resolved. Immediately amount of frustration, we took 2-3 occasions time. And we asked him to deliberate with family members, but he comes back and says the same. How to deal with these kind of situations? We have to think, we have to sit into their mind, look into them, how they are conducting themselves in arbitral proceedings, in mediation proceedings, and what is their mindset. Sometimes some people are flexible and others are not flexible. They understand and resolve the dispute and come together. In one other matter, it belongs to Uttar Pradesh. The boy is from Uttar Pradesh, girl from Delhi. After the marriage, they had 2 children, But then some differences arose. Girl came over to the parents' home and she stayed back for a long time. And filed an application for divorce. It was interested to me when I interacted with both of them, I noticed that both of them like each other. There was no personal animosity of discontent or anything against each other. Both of them love their children and they want to live together. But the husband only complaint is that she always speaks on phone with her parents for a long time. She goes to parents' home and stays in the parents' home for a very long time. Does not come back. We don't like this kind of. My wife says, some money was diverted to parents is another grievance. The wife says, what is wrong in speaking to my parents? What is wrong if I go and stay with my parents for some time? I noticed that it's only a small area of dispute, and ultimately the undercurrent is both of them want to live together and live happily. So I persuaded the lady that she should not indulge in this kind of causing inconvenience to the children as well as husband. That she should not always go back to the parents and stay back for a long time. Girl has agreed and then they're happily living. Matter was resolved and they're happily living. There are several such instances where I was happy of resolving the disputes, and some matters where disputes were almost resolved, but at the last minute they go back on small technical aspects. Therefore, why I am referring to these instances is that as a mediator, our role is only to persuade the parties to understand what is the conflict, basically, major issue of dispute. What is the major issue of dispute? What is their interest? How do you want to proceed further? In mediation matters, there is always two-pronged strategy, and because it is divided into two segments. The first segment is the history behind the problem that arose and the future of that problem and the future of the persons involved in the litigation. As a mediator, you need to tell the parties that you need to forget about the past. It is past. But if you still think about the past, then you will not have a better future in it. Therefore, you need to come out of the past problem and try to solve the problem so that you can appeal. Solving of the problem can be in the manner of matrimonial matter, breaking off and living separately and living happily thereafter, or settling on small misunderstandings and then coming together and living together. For this purpose of dealing with the matters in mediation, to understand the parties, you, according to me, why I am referring to the examples and telling you is, this may be a best occasion for you to train yourself in the techniques of mediation and then be equipped yourself by the time you come out of the topics. Learning of techniques of mediation are very important, but when you go and implement them in practice, when you conduct proceedings, again, you must have the broader perspective in mind, but you have to be very flexible in dealing with the matter. You cannot put in a straitjacket manner dealing with any particular issue on dealing with attending to the parties' mediation dispute. If you conduct mediations properly and establish yourself a reputation of a better, you will have a very good future prospects. You can enhance your profile by acquiring experience, training and qualifications, as well as thorough active engagement with mediation organizations. Higher level training or certification in area of specialization will also enhance chances. Some mediators are also branch out to become teachers, authors, or consultants in conflict resolution. Now there is a new method developed, which is called a hybrid approach called mediation and arbitration, MEDAR. MEDAR system is that people first take recourse to mediation, then go before the arbitrator. It can be vice versa also. So sometimes it is called MEDAR, MEDAR. First mediation, then arbitration and mediation. It can be vice versa also, arbitration, mediation and arbitration. In other words, arbitration and mediation are also combined to resolve a dispute. Again, I take an example when I am dealing with an arbitration matter. Three brothers whose family is well connected to the legal profession for the last 70, 80 years are fighting for getting the benefits out of the family earnings of his father, their father. There was a memorandum of family settlement. Thereafter, again another family settlement between three brothers initially, and another family settlement between two brothers. That family settlement between two brothers envisages resolution of dispute if any arises by manner of an arbitration. Therefore, they have taken the recourse because some disputes arose between those two brothers. Third brother now entered when the matter was pending in High Court, saying that I am also interested in the matter. My share is not properly divided. I did not get the benefits of this settlement. So now three are fighting for that. They are so inimical to each other. I'm really surprised, and yesterday there was one session and told them that please why don't you resolve, I'm feeling very bad of dealing with the dispute. Having regard to your association with the legal profession for 70, 80 years. They said we'll try to explore. But earlier, I took initiative and then conducted mediation proceedings. I being a neutral person without directly involving, because I'm also an arbitrator, allowed them to interact in my presence so to ensure that no untoward incidents can happen. They have deliberated, certain records were taken out, statistics were worked out, and then everything was done. But again, they did not come to a common settlement point. So, mediation, the arbitration continued. So, it's a case of arbitration, mediation, and arbitration. And again, yesterday I told them to explore the possibility of resolving the dispute again by mediation. So, combining arbitration and mediation, I would say, is required, and it is happening also. Upon study and requisite training within the ADR field, a person can be employed by government agencies or think tanks to craft policies promoting the use of ADR rather than litigation. Many arbitration and mediation centers hire law graduates as researchers and case managers. There is one other area which is called ombudsman. An ombudsman acts as a neutral mediator between conflicting parties, typically within the organizations or government. They attempt to settle complaints and disputes through unofficial litigation or arbitration. There is ombudsman system is prevalent largely in banking sector and insurance sector. Even in the sports, also there are ombudsman. BCCI has got a designated person acting as an ombudsman who is normally a retired judge at Supreme Court. In all the state cricket associations, there is a provision of ombudsman who can normally be a retired chief justice of the High Court, and some states also provide for a retired judge of the High Court as an ombudsman. These ombudsmen in sports area, particularly cricket, they attend to the grievances of players versus the association, etc., and among the clubs operating within the association. With reference to the insurance and the banking sector, the individual grievances of the customers are attended to by these ombudsmen, and issues are mostly resolved, small number of disputes are resolved and settled there. Now when it comes back to mediation, as I was saying that the training is essential part of mediation, to be a mediator. The Honorable Supreme Court established Mediation and Conciliation Project Committee in the under the control of the Supreme Court, which has envisaged 40 hours training program to train mediators. I have undergone such training. I, along with the two other brothers retired from the Telangana High Court, senior advocates of Justice Alok Aradhya were the Chief Justice. Alok Aradhya insisted all the senior advocates to undergo mediation training. So few senior advocates and we have undergone this 40-hour mediation training conducted in Hyderabad. And that 40-hour mediation training certificate issued by after the training is completed is essential for you to be recognized as a trained mediator and to act as a mediator. The problem, as I was talking about the Mediation Act not making it compulsory, the mediation is not compulsory, is that enough trained mediators are not available. The problem with the MCPC is that they don't have large number of trainers who can train the mediators. The Mediation Act is not fully implemented. Mediation Act envisaged establishment of the institutions. Institutions can conduct training of mediators and then can give certificates. Once they give certificates, they are valid. Prior to this 40 hours mediation training conducted by Legal Services Authority, I had undergone training of a London-based organization called ADR ODR International. They have conducted 3 days training online and 3 days they came over to Hyderabad and completed the training. Then I have also went to Dubai to undergo one more training session by them. That was on online mediation also. It was the exposure given to me when I was in Dubai. The persons coming from various parts of the world was good. It really gave me that kind of a confidence in dealing with mediation matters. And as a judge, I was encouraging mediation and I was requesting all my colleague judges also to take recourse for mediation wherever possible. When Honorable Justice Guyan was our Chief Justice, we had in fact a 3-day informal mediation training for the judges. All the judges with the families have gathered at one particular place, Kana Shantivana. We have a huge infrastructure created there at that place. All of us moved into that place and stayed for 2 nights and 3 days. It was called as a mediation and meditation course. The people from Delhi training center, they came over and gave us mediation inputs for the judges to understand. So we used to have mediation classes in the morning session and in the evening session. The head of that Shantivana was called Bachi. Used to take meditation classes. So it was a mediation and a meditation, basically intended to have an exposure of what exactly is mediation and what is to be done. That was the starting point, and I have been acquainted. And after my retirement, even though it has become a stressful, handling the mediations, I find it more stressful than handling litigation when I was a judge or arbitration matters. But I have been accepting mediation matters and happy to resolve some matters. And I have been requesting the judges of the High Court to take recourse to mediation because I believe that mediation, however it grows, how much it grows, it would certainly help in reducing whatever percentage of cases in the courts. And it is what required. in this country as of now. As you know, you must have already noticed or analyzed, mediation helps in resolving the dispute of the parties, but it also helps in reducing the litigation, because once dispute is resolved in the mediation, that is the end of the matter. There is no question of litigating on the mediation. So that the burden of the courts in dealing with the dispute will not arise. I will share an example. Husband and my wife were not living together since 1988. In 1988, 3 years later, 91, I believe, case was filed by the husband asking for divorce. The trial court refused to grant divorce, and the petition filed by the wife to grant restitution of conjugal rights was granted. Husband lives in Chennai, wife lives in Warangal in state of Telangana. The judgment was rendered in 2010, and in 2013, the High Court granted stay of operation of the judgment. The result, the restitution has not happened. They were not living together for a long time, and there were 2-3 attempts made for resolution of the dispute by mediation. High Court referred the matter to mediation, but dispute was not resolved. Matter came back to the court. Last time I was appointed as mediator in that matter. And when the mediation proceedings commenced, this is what was told by the lady, sir, it will not be resolved, we were not able to solve the problem. I don't want divorce, I want to live with my husband. I asked 2 questions from her, answers from her. First is, since 1988, they are not living together. The year I am not very sure, because in 24 it was resolved. So 16 years by 24, they were not living together. Husband lives in Tamil Nadu, and husband says, sir, whatever happens to the court, even if I lose the matter in Hyderabad and my divorce petition is dismissed, sir, I'll be going to Supreme Court, I'll contest. I cannot accept her as my wife, I cannot live with her because I have a fear of whenever I come closer to her, that was a problem, therefore I left her. I cannot live with her, it is not possible. Therefore I asked her 2 questions. One is that you are not living together, that bondage is not there, you cannot restrict children. Bondage is not there. How can you establish a bondage after 16 years even if you live together, if you agree? This is one. Number 2, he says, I will not accept any judgment by the court. What follows? You can seek enforcement of the order granted by the family court. He does not comply. What can you do? You can at the most send him to jail. But if he is not willing to accept you, can the law, to what extent law can stretch to make him take you back? So what is the point in fighting the litigation? She has initially said no, but I gave her time twice, and then she came back and said, yes sir, I will take the divorce. Next question was about alimony. She was asking for 90 lakhs rupees, including returning of jewelry and everything. This man, emotionally being satisfied that there is going to be a divorce, immediately agreed, all right, I will give 70 lakhs. The wife was very happy, and then he went back. In the next meeting, he said, sir, I cannot afford to pay that money. Sir, I can only give 30 lakhs. Then wife was disturbed, saying that no sir, how can it be, when you agreed for 90 lakhs, how can they come down? He said, sir, my financial position is this, sir, I can give only this much, otherwise no sir, I'll go and fight the litigation. Again I tried to convince, and ultimately I persuaded the husband to agree, and they agreed to go up to 45 lakhs as an alliance. Return all the jewelry, whatever is available, and everything was returned. And what was resolved in that matter, which made 3 or 4 earlier occasions, was resolved because of their, one may be because of the flux of time, 2 maybe because The wife was convinced ultimately because her father, there was nobody to take care of her. That was the main reason why more alimony was proposed and accepted. Nobody to take care of her, therefore this alimony would help. But there was no bandage. These things were appealable to them. Both of them and them agreed for reservation. Interestingly, one other matter, 91 person has invested 1 lakh rupees in a financial institution, reputed financial company's financial institution. But that company later went into doldrums. The shares of the company were sold to third party. This man filed a consumer case saying that my money is not returned. Consumer court forum granted him 2 lakhs rupees and interest. That was challenged before the state commission by the person saying that I am no more concerned with the company. This particular company where I was the director earlier is no more in existence. So the entire shareholding was transferred to another company. Therefore, this is not binding on me. The consumer state commission accepted. On appeal, the National Commission also confirmed the decision. So, matter is remanded back to the the district forum for impeding the company which succeeded to the earlier company and then pursuing the litigation. I was told during the course of discussion that company notices are not served and should set expiry. He also lodged a criminal complaint against the person, saying that this person cheated me. He filed an application before the High Court for quashing of the proceedings and succeeded before the High Court. And the matter went to Supreme Court. The Supreme Court referred the matter for mediation. The person was waiting for resolution of the dispute and withdrawing the criminal case on the ground that he should be paid 90 lakhs. He calculated the interest on interest and everything ends at 90 lakhs. The answer by the former director, who is the respondent before the Supreme Court, was, "Sir, I resigned as a director in 2000. I sold all my shares in the company in 2000 and nothing to do with the company. There is another company, I am no way concerned. Therefore, I have no liability to pay any amount, I don't have to pay any amount. But sir, out of respect to you and to resolve the dispute and then close the matter, I am willing to give you 3 lakhs rupees, even though financially even I am in big trouble." Later on, he was persuaded to come up to 5 lakhs. So it is 5 lakhs versus 90 lakhs divided by the claimant. I told claimant only one thing. Either you take this 5 lakhs or fight the litigation. Now if you fight the litigation, what is the consequence? What is before the Supreme Court is a criminal case. Now let's criminal court would say that the washing was wrong, let the trial go on. Let the charge sheet be filed and trial go on. What happens if in the trial it is found guilty? This person will be sent to jail. You will have to anyway fight that consumer forum case now. He is not a party anymore. And consumer paid, if you succeed, when can you succeed? One problem. And even if you succeed, recover that money is another problem. And recover from somebody else who is non-existent as of now. So either you take this money or you fight litigation. Choice is yours. You are about 75-year-old. Sir, how can it be, sir, when from 90 lakhs, I came down to 40 lakhs and now he came down to 12 lakhs to 15 lakhs. He is not willing to give you more than 5 lakhs. That is his final decision. He has financial problems, he cannot give. What will you do otherwise? The Mohan ultimately agreed was taken at 5 lakhs and resolved the dispute. So the parties would be at loggerheads. Parties will have a very strict assessment of their entitlement and then stand at a very high level. But if you are able to explain to them the various aspects of litigation, their legal position, their entitlement, their prospects of succeeding, and what they are getting it today, parties may agree and resolve the dispute. All that is required by a mediator is to have the skill to deal with them, train very well, and apply your mind and be positive. I just go back to the introductory statement made by you. No predetermined mindset, not to jump conclusions, have guided conversation, and have a collaborative process. These are essential requirements to be a successful mediator. If you acquire these skills, I'm sure the field is very wide and very big, and you will be 100% successful in becoming a good mediator. And I'm telling you that mediators are also being paid by the private persons when they engage. The amount of mediation is ranging anywhere between 10,000 to 15,000 per session per party. Sometimes it can go up to 1 lakh, 2 lakhs depending on the amount involved. You may have noticed the resolution of a dispute of two big industrialists from Bombay, resolved by Justice Naveen. A long pending dispute between the family members, I think Jindal Group, is resolved by Justice Ravindran. Justice Ravindran, if you look into the research, go to your Google friend, is well known in mediation and arbitration. He has authored a number of judgments when he was judge at the Supreme Court, which are watermark in the arbitration and mediation issues. He is very well known to be a good mediator, and the matter was entrusted to him, and ultimately the matter was resolved very shortly. I think in 2-3 sessions or so, in a very short time, he could resolve the dispute. I'm not very sure whether it is already available in the university curriculum. I request that provide a separate channel of persons, students opting to arbitration and mediation. And in the mediation, with the Mediation Act, with the consideration of the provisions of the Mediation Act, provide training to the, as an in-house training as part of the curriculum. Mediation training for the requirements of mediation, so that by the time they get that mediation certificate and then go out, they are well equipped to deal with, and there is no need for undergoing again mediation training, 40 hours training and then setting a certificate. Now, part of the mediation training is, though there are certain practical problems are also given as part of the training, and but more than that, I would suggest that the persons who are interested in becoming future arbitrators or profession, taking up the profession as part of in arbitration or mediation, they should also attend to the arbitration and mediation sessions as trainees, like to know what they do and go and attend to the courts and be part of the law firms. They should also participate. That will give them the practical exposure to how the training, actually the arbitration proceedings are conducted and mediation proceedings are conducted. The practical training of problems and attending to the training, the mediation sessions will be of great help to them. Another new area that is coming up, and it is in preference everywhere in the world, is online dispute resolution. Resolution of disputes is one thing, but resolution of those disputes online is another aspect. The one I was referring to about the London-based organization, its name is ADR-ODR. ADR is Alternative Dispute Resolution, ODR is Alternative Online Dispute Resolution. That organization is specializing in training all over the world in mediation techniques, including online resolution of disputes. This online resolution of disputes is going to be a new trend, and it can be, if effectively implemented because modern technology enables easy communication. Facilities are available now, transmission is easy, everything can happen. And to share with you that matters referred to me by Supreme Court Mediation Center, or most of the sessions I conduct online only, and the matters which have settled also only because of by conducting online mediation sessions. So it is possible to resolve disputes online. There are techniques we have to learn how to conduct proceedings online. The modern technology enables to have private rooms within the online procedures. You can talk to the parties separately in private rooms and come back to the regular sessions. You can ask the party to exit and then discuss there with other party and ask the other party to again join. So possibilities are enormous, and online is again going to be the future of resolution of the alternative disputes. The disputes by alternative means. For LLM graduates, in arbitration or mediation are in great demand by international law firms, multinational companies and ADR institutions such as International Chamber of Commerce, Singapore International Arbitration Center, London Court of International Arbitration. The transnational aspect of ADR provides professionals with the ability to work in many different jurisdictions and deal with cases that span borders. I also request the LLM graduates to be trained arbitrators and mediators, and you can take up the training as an assignment to train more arbitrators and mediators. There is also a need to undertake study and research on techniques to deal with disputes outside courtroom. The scope of research is enormous. Analysis of cases dealt by Lok Adalat and by mediation is on different issues is one more area of interest. For teaching faculty, ADR offers a rich blend of academic and practical engagement. As educators, you are in a unique position to share future ADR professionals by integrating practical skills training into curriculum, supervising research and hosting workshops or clinics. Faculty can take advantage of their legal knowledge and practical experience towards diversifying and becoming certified mediators or arbitrators, contributing directly to the resolution of disputes and to broader policy discussions on access to justice. You need to make case study and assessment of precedent decisions, participation of law students in arbitration, mediation and negotiation process, and to observe the proceedings. The students should have interaction with arbitrators and mediators. More practical experience should be introduced in the curriculum. The university has to incorporate mediation training as part of curriculum. The training has to be both theoretical and practical. Dear friends, I can confidently say that ADR is no longer a sideline to litigation. It is often the primary, most appropriate means of resolving disputes in today's complex and fast-paced world. Whether you are a student exploring career options or a teacher guiding the next generation of legal minds, ADR is a field full of relevance, responsibility and opportunity. Dear students, pursue certificate courses and train while in law school. Intern with ADR professionals, arbitrators or institutions to gain exposure. Participate in ADR proceedings. Specialize in any branch of commercial law, contract law or international law as a foundation for ADR. Join ADR focused student groups or journals. The potential is huge. Opportunities are still limited. There are several other areas where ADR has made its mark. It is entirely a new world. Grab them with both hands. Now, this is the time. Everyone is knave of what Joseph Grandon said. An ounce of mediation is worth a pound of arbitration and a ton of litigation. That sets up why the arbitration has grown and then why mediation is growing now. all the very best. Thank you all for patient hearing of a trying subject. Thank you so much.
We open the house for Q&A session.
Good afternoon, sir. Good afternoon, everyone. My name is Vasari Sharma. I'm from first year BA LLB. So my question regarding arbitration and mediation is one of the most prominent and landmark cases which we have seen in arbitration and mediation was about White Industries versus Republic of India. It was an international arbitration case about a company and award giving. So one of the major disturbing facts which we noticed, which was noticed in the international grounds by the Australian counterpart of ours, because it was an international matter, they said that there's a continuous judicial intervention even in arbitration matters, where even if big companies are involved, judiciary has a tendency in India to get involved again and again. And the second was the delay in the process itself of arbitration. So how do you think we can deal with this problem, which is a very prominent in international arbitration centers?
You mean it is in India or somewhere else?
Sir, it was in India during 1996. It was just a landmark judgment because in India arbitration and mediation is not a very.
Why I'm asking that question is, as I said when I was speaking also, that on the recent past, particularly in the last 2-3 years, series of judgments are rendered by Honorable Supreme Court, prominently Delhi High Court also, prominently Delhi High Court and other high courts, which have reduced the scope of interference at the interlocutory stage. It's almost nil. See, and they said an order passed under Section 11 for appointing an arbitrator is something like an administrative order. It is not a judicial order. And at that stage, the court is only required to see whether there is an arbitration clause and the notice is issued for invoking arbitration. If these two conditions are complied, you have to leave everything else to the arbitrator and refer the matter to arbitrator. So now I received several Section 16 applications, Section 17 applications. So in the Section 16 application, the scope of consideration, there are again distinct decisions I consider and then pass orders. When you challenge that order, courts are not interfering. That's again the law developed now. That no question of court interfering and entertaining Section 16 applications against appeals against Section 16 orders. You have to wait till the award is passed and then you have to avail appropriate remedy. As I said, again there are judgments of the Supreme Court consistently holding that the scope of interference of the court under Section 34 is very, very limited. Maybe one issue is now pending consideration of Hon'ble Supreme Court with reference to this aspect of interference. What extent the courts can interfere. They wanted to probably lay down certain guidelines. Maybe what happens is, suppose there are 6 issues. One issue is decided which is perfectly wrong. Now you cannot set aside the entire award on that ground. Or you cannot uphold the award if this issue is a crucial aspect without upsetting the other decisions in the other issues. So probably I would assume, I don't know what is actually being argued and what would transpire, is to give some kind of scope of interference only to the extent of the wrong decision made by the arbitrator on a particular issue and remanding the matter to the arbitrator to decide on that issue. Possible. But as of now, the interference by the courts is almost zero at the interlocutory stage. So therefore I don't think it is happening now. But then there are proposals pending in the government for amendment of the Arbitration Act. 2-3 important aspects which will be very encouraging to you in the future generations. One is, main problem now everybody faces is enforcement of an award has become very tough. Again, you have to go through the regular process. That is taking a lot of time because cases are not happening in the civil courts. They treat this matter like any other matter. Therefore, it is pending for a long time. So enforcement is not happening. They want to create a separate tribunal to ensure that the awards are enforced by that tribunal. This again a tribunalization, I don't know how far it would go, is again a different story. The second aspect is they want to also create an appellate forum away from the civil courts where the awards can be challenged before that forum. And hopefully that process may expedite the disposal of cases even in the appellate stage. Well, again the problem now is that the appeals are going to the civil court. And civil courts are treating the said appeals like any other appeal, and therefore these appeals are also pending for a long time. So hopefully things are moving in a positive manner for settling the standards for the arbitral disposal of arbitration matters.
It's stock exchanges, already there is a provision for appellate arbitration. Or commodity derivative or credit.
Good afternoon, sir. Sir, I am having a question. Like, if once the parties has successfully concluded the mediation and they had signed the settlement agreement also, so under what circumstances can one of the parties still initiate the court proceedings? Because I am having a deeper curiosity that if there is a fraud or there is a breach, so how can the mediators and parties ensure that the settlement remains truly final and binding?
According to your understanding, what?
It should be binding.
Okay. Then what is the question?
But I need to get the proper, like what is the guidelines, what is the rules that it says.
Regarding it's binding, is it? Mediation, I also dealt with that. Mediation once resolved, both parties sign the settlement. That is final. Once settlement is recorded and signed, it is binding on them. They can't go contrary to the settlement. If one breaks the settlement, what happens is a different issue. Probably you will have to be forced to take the legal course. But this is treated as an award. You are entitled to seek its enforcement. Please look into the Mediation Act. The Act envisages this contingency also. Only thing is, if it is by fraud, suppose if I can establish that the mediation or I was compelled to sign, I did not agree for settlement. If I can prove that, maybe there is a scope for court's interference, but very, very limited. Again, in that independent litigation, the question of challenging the mediation award does not arise on that ground by him when having signed the document.
Good afternoon, sir. I'm Kanishka Tyagi. I'm in second year. Sir, I want to know your opinion on making ADR a compulsory legal process, especially in civil disputes, because according to me, it should be made a compulsory process because by not making it a compulsory process, we are making it a process that is only available to the elite people and not to the common people.
There are two aspects you will do.
Tanishka Tyagi. Tanishka Tyagi.
Kanishka.
Tanishka.
There are two issues, Tanishka. If you look at the Mediation Act, as I said, initially when the draft was in circulation, the Act envisages compulsory reference to mediation. But when it made into an act, that was deleted. As I said, possible reasons are two. That is, basically the public are not ready to take that course. Therefore, if you suddenly enforce it, may lead to more complications. Number one. Number two is, as I said, there are not enough trained mediators. So very few trained mediators are available. That's why the request was to the Honorable Vice Chancellor was that the training component should be introduced in the curriculum only, and if 40-hour training concept is introduced here and you are trained and you are given a certificate of training, probably you don't have to again undergo the training, and then we can have a larger pool of trained mediators. Unless you have
trained mediators available, if you make the mediation compulsory, how do you enforce it? Where do I go if I have a dispute? Who can be my mediator? That is the problem. And unless you are trained mediator, the various problems that arise in the process of settlement of dispute may not actually help. Unless you have kind of a persuasion capacity with the background understanding of each positions, their background, their history, and what is their interest for future. There are basically three components. You have to convince the party that forget about the past. Live in the reality and then what you want in future. You want to live happily, then why don't you resolve the dispute and move forward. For this you need a trained person to tell them.
This was according to me, for that reason also, ADR should be made a compulsory legal process. Because if we made it, if we are going to make it compulsory, then it will be more.
But tell me, alright, it is made compulsory, I'll tell you. Are it made compulsory? Then, where you go?
More people are going to study.
So hopefully, it's another 4-5 years we will have a larger pool of mediators. Second problem is that mindset. In that area also there requires a lot of education, awareness being created. Mindset of judicial officer, mindset of the litigant. Now, CPC already provided for alternative means of exploring the possibility of resolving the dispute, isn't it? But how many judges are invoking that provision to resolve the disputes? Not happening. As I said, it is possible in high courts to refer matters for mediation, even if there is no provision. Few only are referring and very few matters are being referred. Now, even those matters which are referred are not getting settled because there are no trained mediators, well-equipped mediators. So the problems are coming back. Those, I think, but it will have to happen. I'm sure it will happen. That's the reason why I'm saying please take ADR as a future your course after you are graduating from college. It can be a good professional option.
Thank you, sir.
Good morning, sir. I'm Satish from 4th year. I'm pro-arbitration in general. However, I have one concern with arbitration, that is, there is no formation of case laws in arbitration and that hinders the development of law. And since we are a case law based country, common law system, how do we address that challenge? And since especially our commercial,
No case law.
because say confidentiality clause in arbitral agreements prevents the arbitration agreement, the judgment, the award from being made public, right? So any commercial case law will not be developed and the jurisprudence will not go ahead. So that since there is no court intervention and we cannot rely on previous arbitral awards as precedents.
How can you rely on arbitral award as precedent? Suppose
I'm saying that's the problem.
Forget about arbitral award. In a suit, a decree is passed, judgment is rendered and decree is passed, inter partes. Can that be referred to as a precedent?
No, of course not. But any questions of law that are addressed.
Sir, these civil disputes, when they are decided, they are not precedents. So when they come into higher courts, while considering a dispute and legal issues raised in that dispute, the courts lay down certain decisions, render decisions, which may become precedents. So similarly, arbitrator is nothing but he is stepping into the shoes of the civil judge. He is deciding the dispute. Dispute is binding between the parties. If he decides any legal issue also, you cannot refer to that decision as a binding precedent. It's not binding on anybody.
Exactly, that's what I'm saying.
One area you all have to think and then tell me, or think about and then explore the possibility is this. Incidentally, I'm saying, is when it comes to the structural manner of organizing the courts. In state of Assam, the decision rendered by the High Court is binding on this for the district judiciary. If there is any conflict decision in another High Court, he is bound by this decision and not by the decision of another High Court. When it comes to arbitrator, which decision is binding on the arbitrator? A decision of Allahabad High Court or a decision of Telangana High Court for me? Which is binding on me?
That depends on where the cause of action arises. Or if,
Who said?
I mean, or else if we already agree to a jurisdiction in the agreement
Who
itself.
said? Again. That. So there are some grey areas about
Yes.
that. So what we are trying to do as of now is to reconcile and to see that it is applicable, and if preferably go with the local law. If there is serious conflict and one view is taken by the local court.
Yes. But then the larger question still remains that suppose a new point of law is decided by an arbitrator.
Sir, I said,
Yes.
again you go back to the same example. Sir, if a civil court decides, the junior civil judge decides the legal issue also, and the society is the president.
No, it's not a precedent, that's my
Same thing.
We will no longer be going to the.
I am only stepping into the shoes of an arbitrator, the junior civil judge deciding on my dispute, that's all. Nothing more.
Okay, sir. Thank you.
Swami.
Good afternoon, sir. So, sir, my question was a bit more abstract in this regard, that whether the increasing use of ADR would inherently create a two-tier system of justice. As we have repeatedly pointed out that we don't have the requisite number of mediators right now, and private dispute resolution under ADR is limited to wealthy individuals as well as corporates. And then we have public courts which necessitate the justice dispensation of the ordinary person. So, would you say that with an increasing use of ADR in the future, we might have developed a two-tier system of justice?
Reason is twofold. Your name?
So it's Aruni Swami.
Swami. The reason is twofold. One is, what is decided in an arbitration or a mediation is a regular dispute only. Dispute is same, whether it is decided by a civil court or decided in a mediation or resolved in a mediation or decided by an arbitrator. So therefore the basic issue is same. Number two, for arbitration or mediation, it is the party's wish. If the parties want to go before an arbitrator or mediator to resolve the dispute, it can go. Not otherwise. Otherwise, it's a civil dispute. You have to go before the civil court and then resolve the dispute before the civil court. So when you enter into a contract, the contract envisages, if it envisages that any dispute has to be resolved by an arbitrator, then arbitration mechanism will be invoked. Similar such clauses are being incorporated in contracts now regarding mediation. Even if it is not incorporated, courts can always refer for mediation. Now, when it comes to mediation, if there may be a serious dispute before it, it may have gone before the court or had to go before the court. But parties sit together and resolve the dispute. When it is not a decision rendered on a particular person's stand, say I have a grievance against X that I am entitled to receive from X 100 crores. He says I am not entitled to pay zero, even if zero, 1 rupee also. The other side would say. And he says, in fact, lot of damage is caused to me. I have a counter claim. I am demanding from him 50 crores. That means 150 crores reverse. When they sit together, they ultimately agree that no money need to be paid by me, or no money need to be paid by X, but hereafter we will conduct our business in this manner, which will be both conducive to working of both companies, both persons. We live happily, live together, live happily. It is not a decision made in the sense of a binding decision where it can be appealed and gone to higher courts. It is a settlement arrived by the parties to resolve their dispute amicably by conceding each of them of their stand and then coming to a conclusion. In that manner, it cannot take the course of a regular course. Another example I told you is that there are more than 6 crores cases pending, with around 8 to 9 crores. Litigation in various manner, various claims. Even if 10% of that litigation coming to courts, it comes to around 60 to 70 lakhs of cases. But what happens to the rest of the cases? They're still in the regular line only. But we need to have alternative dispute resolution mechanisms adopted very seriously in India is because the pendency is very high. Resolving the pending cases, as many people are saying, will take 200 to 300 years. That is not conducive for anybody, but overall growth of the country in all respects. So I don't think you need to have any negativity of whether this mechanism will take over the regular legal system. It will never happen.
So my question was when you started by pointing out as it should be called appropriate dispute resolution.
Yes.
Thank you so much.
We will start using that word, appropriate dispute resolution.
Thank you so much.
Good afternoon, Lordship. Sir, my question pertains around international dispute resolution. As to in the UN Convention on International Settlement Agreements, which is also known as the Singapore mediation. Sir, my question centers that India has signed the agreement as to if they want to participate in this international convention, but they has not yet rectified this. Sir, the reason for which, as underlined by eminent figures of arbitrators in India, is that they are waiting for other economies to rectify it first. Sir, what do you, I want to know your interpretation in this regard as to should India rectify it or should they wait for other countries to rectify it?
In the informal discussions, what is told is there are certain clauses which are not conducive for India. So that's the reason why the Indian government is not accepting the as of now. That's the main reason given. But when it comes to the resolution of disputes, why they are not coming to India and then why they are going to Singapore or now Dubai, is mainly because of the litigative process in India. They are afraid of the amount of time it consumes in resolving the disputes in India. And so far as international arbitration, resolution of disputes of international companies is concerned, they are not satisfied with the amount of infrastructure created in India, like what is done in Singapore and what is being done in Dubai. Dubai, the government is actively supporting and encouraging arbitration and mediation centers grow, and then therefore the matters are being diverted there. Cost effectiveness also, accessibility also. Dubai is treated as more accessible to the European countries than coming over to India. Singapore, earlier London used to be the main center. It became very expensive. Then Singapore also has become very expensive, and therefore now people have turned to Dubai. So there is still a scope of attracting the cases now being moved to Dubai to India, but we need to create infrastructure. Steps are being taken, like arbitration centers have come up with India. Hyderabad has one good arbitration and mediation center. Delhi has one very good one. Bombay, several in Gujarat, very good center is established. They're coming up now slowly. But major concern for them not to incorporate even a clause in their agreements showing India as a place where the matter can be settled is they are not satisfied with the infrastructure, facilities available and the litigative process. It will take some more time before we can attract those cases to India itself.
Can I take it as a yes? There is an urgent need for rectification.
No, ratification has got its own problems. That's what the government says. Not agreeing but doing it unless those agreements are entered into with the respective states only.
You are telling, sir, that there are facilities that need to be incorporated to further this rectification, right?
But that is one of the aspects I am saying. Cost is one. People like look at it. Cost wise, we are not expensive. but we don't have the exposure to the world level to say that yes, we have all the infrastructure, we have the technical manpower available. You see, the international arbitrations, they don't mainly rely on the judges or retired judges dealing with the matters. So they look for more experienced experts in the respective branches of the dispute where it arises. So that kind of the workforce, people are not available in India who can handle the arbitration matters of higher scale. Now most of the international arbitration matters which arise in India are handled by the judges of retired from Supreme Court. Only in the judicial minds are of, but not technically. There may be a panel of arbitrators where the technical persons are also inducted, but not many.
Thank you for the question. Thank you, Honorable Lordship, for taking us through the nuances of alternative dispute resolution. The practical insights brought forth by you have assuredly strengthened our understanding of the challenges and possible solutions in this area. Thank you again, sir, for your time and presence. To conclude the proceedings, may I now call upon Registrar Sir, Shri Gunojit Roy Chaudhary, to propose the vote of thanks.
Good afternoon, everyone. It is with immense gratitude and pleasure that I stand before you today to convey our sincere, heartfelt thanks on behalf of National Law University, Assam. First and foremost, I would like to convey our deep regard and sincere gratitude to our today's guest lecturer, Honorable Mr. Justice P. Naveen sir, former Judge of Telangana High Court, for gracing us with his presence and sharing his valuable insight with us. Your wisdom and experience have enriched our understanding of the challenges and opportunities that lie ahead of us. We hope to continue to receive such support and motivation from the Lordship in the days to come. Thank you once again, Lordship. I express special thanks to our Honorable Vice Chancellor, Professor K.V.S. Sharma sir, for his constant help, guidance, and his meticulous effort for making this event a successful one. I also take the opportunity to thank our faculty members who are present here today and grace this occasion. I express special thanks on behalf of National Law University Assam to our students for their presence and make this special lecture a successful one. I am certain that the quality time given and the experience rich knowledge disseminated today has enriched not only the student but also one and all present here today. This will go a long way in widening the outlook of each of us and play a pivotal role in shaping the thought process and action hereafter in a whole new dimension. As we conclude this session, let us carry the spirit of knowledge and camaraderie forward. Let us continue to strive with excellence in all our endeavor and uphold the values that made our university a beacon of knowledge and innovation. Thank you once again who are present here and contributed for successful completion of this.
I have one small request, attention. I proposed, subject to the university permitting me, to institute one gold medal, either in arbitration or ADR. I would prefer ADR, and I wish to be present physically when one of you receives gold medal next time.
Yes. Thank you.